Every society evolves, and with it, the very fabric of its laws. In the pursuit of justice, some organizations take on a unique role, standing at the intersection of charity and political change. But as the legal landscape shifts, a critical question arises: can trust for organizations promoting law reforms be valid? Welcome to Charitable Trust Dilemma. Picture this: an organization passionately committed to law reforms, seeking the coveted status of a charitable trust. But as we delve into the complexities of this unique scenario, we confront a pivotal question that demands our attention. We turn to legal experts for their crucial insights.
Charitable trusts traditionally revolve around causes like education, healthcare, and poverty alleviation. But when it comes to politics, we have to be careful as it introduces a complex debate, blurring the lines between charity and advocacy.
The core issues lies in the intended purpose of charitable trust. While advocating for legal changes is undoubtedly important, it raises questions about whether it really brings benefits to the public.
What, in your opinion, defines a charitable trust? And how do law reforms fit into this equation?
In Malaysia, there is no definition provided for the word charitable trust, as there is no specific statutes governing the charitable trust except in Sarawak. But charitable trust can be defined with any trust administered for the furtherance of any charitable purpose. So what is a charitable purpose? Charitable purpose means any purpose relating to the support and advancement of education, religion, sports, and for the relief of property and the aged, and for a purpose which are exclusively charitable and for public purpose. So law reforms or any political agenda often being associated with the advancement of education, as political agenda can be linked with education for the public. They educate the public about their political agenda. It also being associated with the public purpose. Political organizations claim they are doing that for public purpose. They claim that the law reforms they bring is for the benefit of the public. But can political purpose really fall under the scope of charitable trust?
Political objects have a negative role in the law of charitable purpose. A trust is generally charitable if it fulfills two positive requirements, that it be for a charitable purpose and for the benefit of the public. But political objects cancel those matters out. A trust which fulfills both positive requirements will not be charitable if its main purpose is to attain political goals. Significantly, trust to seek law reforms are invalid because to fight for legal change is considered political. This has been the law since 1917, as established in the leading case of Bowman and Secular Society. In this case, it was not invalidated due to illegality. Rather, the court held that it was in no position to assess whether the proposed legal changes would genuinely benefit the public. Since we generally do not have any specific statutes, Malaysian law of charities has been heavily influenced by the English case law.
Amidst the fervour for societal change, legal battles ensue. Challenges to the very validity of charitable trust for law reforms are met with formidable arguments. But where does the line truly lie?
How do you justify the trust involvement in law reforms as a charitable cause?
Our mission is rooted in social progress. We believe that advocating for just and fair laws is a cause worth supporting, and it falls well within the broader scope of charitable activities. And we sometimes fight for law reforms by encouraging political debate in the public. Isn't this definitely good for the public? Some argue that the intersection of charity and politics is not only valid but essential for driving meaningful change. But is it correct in the eyes of the law?
No. As a general rule, political purpose is not charitable purpose. However, yes, there was a case where the court accepted the political cause as a charitable trust, which is the case of Aid or Watch Incorporated and Commissioner for Taxation, where in this case, the objective of the trust was to agitate political and public debate. However, it has to be noted that in that case, although it is a part of political activity, but the court held that their objective is not to seek for the law reforms. Rather, the Aid or Watch organization encouraged public debate as to the best method for the relief of poverty by the provision of foreign aid, and the court held that for that purpose, it was beneficial to the community.
If the political purpose is just an ancillary purpose, then it can be rendered valid. But if the main purpose of the trust is to fight for the political purpose, then the court will be inclined to reject it. This principle can be seen in the case of Molloy and Commission of Inland Revenue, where the Charities Commission had refused to register Greenpeace as a charity on the basis that two of its purposes were political, so it was not a mere ancillary purpose.
But this is not just a courtroom drama. It's a matter that resonates with people from all walks of life. We took to the streets to hear from you, the people, on whether such trust should be deemed valid.
Do you think charitable trusts for law reforms be valid?
I think it's very great if they are fighting for positive change, and why not we support them?
It's tricky. I think charities should focus more on traditional causes, not political agenda.
I never thought about it. It's a tough call.
Public sentiments echo through the streets, revealing a myriad of perspectives. But public opinion will not affect the law. It is a matter of legal principle. Any last words?
So, the charitable trust for political organizations seeking law reforms cannot be valid because the court cannot judge whether an effort to change the law will or will not benefit the public, because that will involve the law stultifying itself.
The answer for today's documentary is in the negative. The court has no means to judge whether the political purpose will be beneficial to the community or not, and I think it should remain that way in order to protect the court's institutional integrity.
Now, the conclusion becomes clearer. The trust for organizations promoting law reforms is not valid. Thank you for joining us.